Welcome back to the deep dive. So, if you've ever wondered how the legal system, decides if someone is really responsible for a crime, not just did they do the thing, but was their mind like guilty too? Well, you are definitely in the right place today. We're doing a really crucial deep dive into the absolute basics, the engine, really, of criminal law. We're looking at the core ideas of accountability from Chapter 6 of the Texas Penal Code.
Yeah, and these four sections, 6.01 through 6.04, they're the essential building blocks. I mean, for pretty much every single criminal offense in Texas law, we're talking about the twin pillars, the physical act with what the law calls voluntary conduct, and then the mental state, the culpability. Honestly, if you're studying for an exam or, just want to be a properly informed citizen, getting these nuances down, it's just non-negotiable.
Right. And our mission today is to take this, let's face it, pretty dense legal language and just break it down, make it into clear, hopefully memorable concepts. By the end of this, you should really get how the law tells the difference between, say, an accident and a careless mistake or something you foresaw versus something you actually intended. We'll just walk through the statutes one by one. So the physical act, the mental state, what those states mean, and finally, proving the action caused the result.
Exactly. It's the difference between just knowing, the illegal outcome happened and truly understanding the state's burden. They have a rigorous job to prove fault. Because without that voluntary act and the right culpable mental state, well, the whole case for criminal responsibility can just fall apart.
Okay, so before we really lift the hood on this legal engine, if you find this kind of detailed analysis useful, please do take a second to subscribe to the channel. Seriously, your support, that's what helps us grow and lets us actually dedicate the time needed for these deep dives. And like always, check out the website. We've got notes there on the source material, plus other guides. Okay, let's unpack this then, starting with the physical side. What do you actually have to do? So, when we think about committing a crime, usually the action itself comes to mind first, right? The theft, hitting someone, maybe not doing something you were supposed to. But Section 6.01 lays down the most basic rule. The conduct, whatever it is, it has to be voluntary. The core idea in 6.01 seems simple. A person commits an offense only if they voluntarily engage in conduct. And conduct can mean an act, an omission, or even possession.
Right, but conduct here is actually a very specific legal term. And voluntarily is like the gatekeeper. It means the physical movement, the action, has to come from a willed muscular movement. Your mind had to choose to make your body move. This is so fundamental. It's the basis for a lot of defenses. Things like automatism, reflex actions, or maybe things done while sleepwalking or during a seizure. If the body moved, but the mind didn't choose that movement, then that element, voluntary conduct, it just hasn't been met. No crime under this section.
Okay, so let's say someone pushes me, like really hard. And because they pushed me, I stumble and knock someone else over, injuring them. My body moved. Sure, there was an act. But that wasn't voluntary conduct by me, according to this definition.
Exactly. The focus is entirely on your will initiating your movement. That's why the law is so careful to distinguish between just, physical motion and will conduct. We only punish chosen behavior.
Yeah.
If it's purely reflexive, like you touch a hot stove, pull your hand back instantly and knock over a glass, that's generally not seen as voluntary conduct. The reaction kind of bypasses the conscious thought process. You didn't choose to hit the glass, your body just reacted.
Okay, that makes sense. Now, let's switch to something that trips a lot of people up. Voluntary possession. That's covered in 6.01b. I think most people assume, like, if drugs are found in your car, boom, that's possession. End of story. But you're saying the law is a bit more, nuanced. It gets that sometimes we end up with things we didn't ask for.
Absolutely right. The statute actually gives two clear ways possession counts as voluntary. The first one's pretty straightforward. The possessor has to knowingly get or receive the thing. You went to the dealer, you paid, you took the illegal item. Clear choice. But the second way, that's where the courts spend a lot more time arguing. It says the possessor has to be aware of control over the thing and aware for a sufficient time to allow them to terminate that control, get rid of it.
Okay, that sufficient time part seems really key. So if someone drops, I don't know, a baggie of something illegal into my shopping cart in a crowded market and I don't notice right away, am I guilty the second it lands?
No, not under this standard. The law gets that you need time until you're aware of it, until you know you have control, and until you have a realistic chance to end that control. That voluntary element is just missing. The law gives you that window. Now, what counts as sufficient time? Well, that really depends on all the circumstances.
Right.
If you find, say, drugs in your car and you immediately drive to the nearest safe place like a gas station and call the police, your possession was brief, and your action shows you intended to end your control, that looks pretty good for you.
But on the flip side, if you realize it's there, maybe you panic and you drive around for hours thinking about what to do, even if you don't touch it again. That choice to just keep control for that sufficient time, that meets the requirement.
That's likely how a court would see it, yes.
Mm-hmm.
The voluntary act there isn't getting the item, it's the conscious decision not to get rid of it or not to call the police when you had the chance. So the prosecution has to show more than just you being near the item. They have to prove awareness and that conscious failure to ditch it when you could have.
Got it. Okay, last part of 6.01 is subsection C about omissions. When not doing something becomes a crime, why is it that generally the law doesn't punish people for just failing to act, like failing to help someone?
This gets into some pretty deep policy stuff about individual liberty.
Right.
Generally, the law doesn't force people to be good Samaritans, to jump into other people's problems. Imagine if we punished every time someone morally failed to act. The legal system would be, well, completely overwhelmed and really intrusive. So 6.01c puts clear limits on it. An omission failing to do something is only a crime if a specific law says that omission is an offense, or if some other law imposes a duty on that person to act.
So if I see a car crash and I just drive by, maybe that's morally questionable, but it's not a crime in itself. But if I was involved in the crash and a state law specifically says drivers involved must render aid, then my failure to act is a crime because the law created that specific duty for me.
That's the critical difference, exactly. Other common duties might be, a parent's duty to care for their child, or maybe a duty imposed by your job, like a lifeguard on duty or a doctor with a patient. But without that explicit legal duty written down somewhere, just failing to act doesn't meet the voluntary conduct requirement. It really underscores the idea that the government has to be super clear when it's going to punish you for not doing something.
Okay, so we've established the act has to be voluntary. The body has to choose to move. Now we move from the body to the mind. And this is really where criminal law gets into defining responsibility. Section 6.02, culpability, the mental state.
Yeah, this section is really the heart of it. It's the core statement that criminal law punishes the guilty mind, what lawyers call mens rea. Section 6.02a gives us the general rule. Unless there's a specific exception, a person has to act intentionally, knowingly, recklessly, or with criminal negligence. You need one of those mental states connected to the voluntary act we just talked about.
But what happens if, say, the legislature passes a new law, maybe something complex about online privacy, and they just forget? They forget to write in knowingly or intentionally. Does that mean any accidental slip-up, any accidental breach suddenly becomes a crime?
That's exactly what 6.02b and c are there to prevent. This is honestly maybe one of the most important safeguards in the whole penal code against, well, accidental prosecution. Section 6.02b says, look, if the definition of a crime doesn't clearly state a required mental state, one is still required anyway. Unless the definition plainly dispenses with any mental element. It has to be super obvious that no mental state is needed.
Wow. So the default setting is mental state required. The law basically assumes we only punish people who meant to do wrong or knew they were doing wrong or were way too careless. The prosecution still has to prove some level of fault, even if the lawmakers forgot to put it in the statute.
Absolutely. The thinking behind it is all about due process, about fairness. We save criminal penalties, jail time, huge fines, that public stigma for people who are actually morally blameworthy. Strict liability, where you punish the act regardless of intent, that's usually saved for minor stuff like maybe some traffic tickets or business licensing rules. And even then, the law usually have to be written very clearly to plainly dispense with needing a mental state. If the lawmakers are silent, the court has to assume a mental state is needed.
Okay, and then 6.02c tells us which mental states count if the statute was silent.
Correct. If a mental state is required because the statute was silent under subsection B, then subsection C says proof of intent, knowledge, or recklessness is enough. Now, notice what's missing there. Criminal negligence is not enough if the statute is silent. That's a critical point.
Wait, hold on. Why leave out criminal negligence from that default list? Why isn't that enough if the law is silent?
Good question. It's because criminal negligence is about failing to see a risk that you should have seen. The other three, intent, knowledge, recklessness, they all involve some level of conscious awareness. Either you wanted the result, you knew it was practically certain, or you saw the risk and ignored it. By excluding negligence when the statute is silent, 6.02c basically forces the prosecution to prove the defendant's mind was actively, consciously involved in the wrongdoing in some way. It keeps a higher standard of actual fault when the law itself isn't perfectly clear.
That's that's actually a really powerful protection for people. It puts a big burden on the state if the law wasn't drafted precisely.
It does. Now, moving on, 6.002d just organizes these four mental states into the official hierarchy. It goes
Yeah.
from highest fault to lowest: intentional, knowing, reckless, and then criminal negligence. And this order isn't just for show. It affects charging decisions, plea bargains, how juries are instructed.
Everything. And you see the practical use of that hierarchy in 6.02e, right? Which seems really important for how trials actually work. It says proving a higher level of culpability automatically proves any lower level if that lower level was what was actually charged.
Exactly. This is how prosecutors handle cases and how judges guide juries, especially with lesser included offenses. So let's say someone's charged with murder, which usually needs intentional or knowing conduct, but maybe the jury thinks, well, we're not sure they intended to kill, but man, their actions were incredibly reckless. The prosecutor doesn't just lose the whole case, because proving intentional conduct also proves reckless conduct, since it's lower on the hierarchy. The jury can still convict on the lesser charge of manslaughter, which only requires recklessness.
Huh. So it prevents someone from walking free just because maybe they were more guilty than the prosecutor initially charged, or because the jury had a slightly different read on their exact mental state?
Precisely. The logic is pretty solid. If you intended the harm, you were definitely aware of the risk of that harm and you disregarded it. So the higher mental state just naturally includes all the ones below it.
Makes sense. Okay, finally in this section, 6.02 F, a specific rule just for city and county laws. Why is that needed?
Yeah, this is sort of like a consumer protection rule for dealing with local government rules. Section 6.02 basically stops cities or counties from creating really expensive, strict liability offenses on their own. It says local ordinances cannot get rid of the need for a culpable mental state if the fine for breaking that ordinance is more than a certain amount, set by Section 12.23. So if it's a potentially big fine, the city or county still has to prove you had some fault intent, knowledge, or recklessness. They can't just punish you for an expensive accident without proving you are mentally culpable.
Okay. So if you accidentally violate some complicated local zoning rule you didn't even know existed and the fine is huge, the city can't just say, too bad, pay up. They'd still have to prove you knew you were breaking the rule or intended to.
Generally, yes, if the fine exceeds that statutory threshold. It ensures a level of fairness and due process, even for local rules, when the penalty gets significant.
Okay, now we get to the really interesting part. This is where the law draws the lines, where it distinguishes between, a terrible choice and just a careless mistake. Section 6.03 gives us the actual definitions for those four mental states. We probably need to slow down a bit here because the exact words, they mean everything.
Oh, absolutely. These definitions are the scalpels of criminal law. If you misunderstand these, you misunderstand criminal liability itself.
All right, let's start at the very top. The one we probably all feel we understand intuitively. 1, intentional with intent. That's 6.03a.
Right. Intentional is the highest level. The law says it's your conscious objective or desire to either engage in the conduct itself or to cause the result. It's all about purpose. Why did you do it? If you rob a bank, your conscious objective, your desire is to get the money. If you shoot someone and your conscious objective is that they die, that's intentional murder. You are aiming directly for that prohibited result.
The bullseye state, like you said. You aimed for it, you wanted it. Okay, now, one step down. 2, knowingly with knowledge under 6.03b. And here, you mentioned there's a really important split in how knowing is defined, depending on if we're talking about the conduct or the result.
Yes, this split is absolutely fundamental. So listen closely here. When we're talking about the nature of your conduct or the circumstances around it, you act knowingly if you are simply aware of the nature of your conduct or that those circumstances exist. For example, maybe you're carrying a briefcase. If you are aware that the briefcase is full of stolen cash, you acted knowingly regarding the circumstance, possessing stolen property.
Okay, just being aware of the situation or what you're doing. But it's different when the law look at the result of what you did.
Yes. Regarding the result of your conduct, you act knowingly if you are aware that your conduct is reasonably certain to cause that result. See the difference? Intentional is desire. Knowing is awareness of near certainty. Maybe you don't desire to hurt the bystander next to your target. You only desire to hurt the target. But if you detonate a bomb right next to them both, knowing it's reasonably certain the bystander will also be killed or injured. You acted knowingly regarding the bystander's death or injury.
So going back to the bank robbery example, the robber might not want the teller dead, they just want the money. But if they fire a warning shot into the ceiling of a crowded lobby and they know it's reasonably certain that falling debris could seriously injure someone, they're acting knowingly towards that potential injury result.
Exactly. You're held responsible for the consequences you know are practically certain to happen because of your actions, even if those consequences weren't your main goal.
Okay, now we take that big step down into the realm of risk. Tier 3. 3. Recklessly is reckless. That's 6.03c. We're leaving desire and certainty behind now.
That's right. Recklessness hinges on two main things. First, the person has to be aware of, but consciously disregard a substantial and unjustifiable risk. That risk could be that certain circumstances exist or that a certain result will happen. That phrase, aware of but consciously disregards, that's the key. They saw the danger sign, they understood it, and they blew right past it.
So you know there's a big unreasonable risk, but you decide to do it anyway, like maybe juggling flaming torches next to gasoline pumps. You don't want an explosion, but you know the risk is huge and pointless, and you consciously disregard it.
That's a vivid example, yes.
Yeah.
You're aware of the risk, you know it's substantial, you know it's unjustifiable, but you choose to ignore it. And the second key part is the standard we judge that disregard against. The disregard has to be a gross deviation from the standard of care that an ordinary law-abiding person would exercise in that same situation. Gross deviation is what makes it criminal. It's not just a little bit careless. It's way off the charts of normal behavior. An ordinary person wouldn't juggle fire next to gas pumps.
Okay, gross deviation. That seems important. Now, the last one, the lowest level, and the one I think gets mixed up with reckless all the time. 4. Criminal negligence is criminally negligent. Section 6.03.
Right, and here's the absolute core difference. If reckless is knowing the risk and ignoring it, criminal negligence is not knowing the risk when you should have known. The definition says a person acts with criminal negligence if they ought to be aware of a substantial and unjustifiable risk. They didn't actually see the risk, but any reasonable person in their shoes would have seen it.
So sticking with risky driving, the reckless driver saw the bridge out sign, knew it was real, and sped up anyway. The criminally negligent driver, maybe they were texting and driving, never even saw the bridge out sign, and plunged into the river. They weren't aware of the specific risk at that moment, but they ought to have been aware of the general, substantial risk created by texting while driving.
That's a good way to illustrate it. The criminally negligent person is, in a sense, culpably blind to the risk. They fail to perceive it. And critically, just like with recklessness, that failure to perceive the risk must also be a gross deviation from the ordinary standard of care. That gross deviation standard applies to both. It ensures we're only criminalizing really extreme carelessness, not just simple mistakes or ordinary civil negligence.
Okay, so that gross deviation standard is the common link. We only bring criminal charges when the failure to look or the failure to think or the failure to prepare is so bad, so far beyond what a normal, careful person would do that it shocks the conscience. Like maybe never inspecting safety equipment on a public ride for years versus just missing one small item on one inspection.
Exactly. That distinction is vital. Let's just hammer it home one more time for everyone listening. Recklessness. You are aware of the big unjustifiable risk and ignore it. It's a conscious disregard, criminal negligence. You are not aware of the big unjustifiable risk, but you should have been, and your failure to see it was itself a gross deviation from reasonable care. Both involve that gross deviation, but the key difference is awareness versus failure to perceive. All right, so we've got the voluntary act, the body moving by choice. We've got the culpable mental state, the guilty mind, whether intentional, knowing, reckless, or negligent. The last piece of the puzzle, at least for crimes where a specific result has to happen, like homicide or assault or criminal mischief, is proving that the first two things cause that required result. That's section 6.04. Causation, the chain reaction.
Causation sounds pretty straightforward, right? Did A cause B? But life's messy. Sometimes there are multiple factors, other injuries, intervening events, which is probably why the law uses this specific but-for test language in 6.04a.
Yes, exactly. The but-for test is the starting point, the basic requirement. The question is, would the result have happened but for the defendant's conduct? Even if, say, the victim was already dying and would have died 5 minutes later anyway, if your specific action made them die sooner. Your action is still a but-for cause of the death at that time. But if the result was absolutely going to happen exactly what it did, completely regardless of what you did, then that chain of responsibility might be broken.
Okay. But what about when multiple things are happening at once? Multiple people acting, or maybe an act of nature combined with a person's actions? The statute jumps right into that with the concurrent cause rule.
Right. The rule is the defendant is still responsible, even if their conduct was just one of several causes acting concurrently at the same time. Think about two people shooting a victim at the same instant. Maybe either shot alone would have been fatal. Under the concurrent cause rule, both shooters' actions operated concurrently to cause the death, so both can be held responsible.
But there is an exception, right? A way for a defendant to argue their action was just too minor compared to something else that happened.
Yes, but it's an extremely narrow exception and very hard to prove. The actor is only off the hook if the other concurrent cause was clearly sufficient all by itself to cause the result, and the actor's own conduct was clearly insufficient to cause it. Both parts have to be true. Imagine defendant A gives someone a tiny shove, causing maybe a small bruise. At the exact same second, defendant B hits the victim over the head with a lead pipe, killing them instantly. Defendant A might be able to argue their little shove was clearly insufficient, while the pipe blow was clearly sufficient. It's a high bar, though.
So the takeaway is basically, unless what you did was demonstrably irrelevant, completely incapable of contributing meaningfully to the harm, you can't just blame someone else, or bad luck, if your culpable act was also in the mix causing the result.
That's the gist of it. If both actions contributed in a meaningful way, even if one contributed way more than the other, concurrent causation usually means both are still on the hook legally.
Okay, now let's get to 6.04b. This deals with transferred intent and transferred injury. This seems really important for making sure people don't get off the hook just because they were, like, sloppy criminals or had bad aim.
Absolutely. This section basically says your guilty mind follows the harm you cause, even if the harm isn't exactly what you planned. A person is still criminally responsible if the only difference between what actually happened and what they wanted or planned for or risked is one of two things.
Okay, scenario 1. A different offense was committed than the one intended or risked.
Right? This often comes up when things escalate. Maybe someone intends only a simple assault, a punch, which is a misdemeanor, but they hit the person in just the wrong way, or maybe use an object and cause serious bodily injury. That might make it aggravated assault, a felony. The law essentially says their initial intent to cause some harm transfers up to the more serious resulting harm, holding them responsible for the felony, assuming their actions created that risk. Your culpable mental state doesn't just vanish because the outcome was worse than you specifically planned, as long as your conduct risked that worse outcome.
Okay, that makes sense. And the second scenario, the classic one. A different person or property was injured, harmed, or otherwise affected.
Yeah, this is the bad aim rule. If you swing to punch person A, that's your intentional conduct.
Yeah.
But you miss, and you accidentally hit person B standing next to them. Your intent to hit A, it transfers over to B. You're held criminally responsible for hitting B, just as if B had been your original target all along. The policy idea is pretty clear. We shouldn't let someone escape responsibility for the crime they intended just because they were clumsy in carrying it out. Your guilty mind caused harm. Who exactly received the harm is secondary.
Okay, I need to push back on that a little, or at least clarify. Does the level of intent transfer perfectly? What if the actual result was completely unforeseeable, even if the initial act was reckless? Like, say I recklessly fire a gun up in the air in a field, just being stupid. I'm aware of some risks, sure, but the bullet travels way further than expected, ricochets off a plane I didn't see, and kills someone miles away I had absolutely no idea was there. Does my initial recklessness still transfer fully to make that homicide, even though that specific result was totally bizarre and unforeseeable?
That's where the precise wording of 6.04b and general causation principles come in. Remember, the transfer applies if the only difference is what you desired, contemplated, or risked. If the result was so incredibly bizarre, so far outside the scope of any risk a reasonable person would associate with your initial act, what lawyers sometimes call an intervening and superseding cause, then maybe, just maybe, the causation chain breaks. The transfer might fail because the result wasn't within the risk created. However, in most cases, even with something like a ricochet, if the type of harm, like someone being hit by a bullet fired recklessly, was within the scope of the risk you created by firing the gun, the statute generally holds you responsible. The law tends to focus on the fact that you initiated a dangerous chain of events with a culpable mental state, recklessness in your example. Section 6.04b, make sure that initial fault usually follows the consequences, even unexpected ones, as long as they aren't utterly disconnected from the initial risk.
Got it. So that transferred intent rule is pretty powerful, really ensuring that initial conscious fault usually sticks, regardless of exactly how the harm played out. Hashtag tag outro. Well, we made it through. We've navigated the four pillars of criminal responsibility in Texas, according to Chapter 6 of the Penal Code. We started with the bedrock, the voluntary act, the willed movement. Then we layered on the requirement for a culpable mental state, intentional, knowing, reckless, or criminally negligent. We dug into the precise definitions of those mental states. And finally, we tied it all together with causation, proving the link between the act, the mind, and the result.
Yeah, and the main thing to take away, I think, is just how carefully the system, through these sections, tries to punish actual fault, not just bad luck or circumstance. It really demands proof of both the physical action and that guilty mind before it assigns criminal responsibility.
Absolutely. And for you, listening and learning, if there's one thing to really burn into your memory from today, it's probably that subtle but crucial difference between recklessness and criminal negligence. Remember, recklessness is seeing the risk, knowing it's there, and consciously deciding to ignore it, that gross deviation in judgment. Criminal negligence is failing to see a risk that you absolutely should have seen, and that failure itself is a gross deviation. It all hinges on awareness.
Which actually brings up kind of an interesting point to chew on later. We talked about how 6.02b forces the state to prove a mental state even if the law is silent, unless it's plainly dispensed with. So thinking about that, how often does 6.04b, that transferred intent or injury rule, really come into play when someone was only risking a result, meaning they were reckless or maybe negligent, and they end up causing a different, maybe more serious crime than they specifically anticipated? The tension between the state having to prove that initial mens rea, especially if the statute's silent, and then the broad reach of transfer of responsibility, it really shows you what a careful balancing act this whole system of accountability tries to be. Something to think about.
Definitely food for thought. Well, hopefully, this deep dive into the foundations of the Texas Penal Code gives you a much stronger framework for understanding criminal cases. Thanks so much for joining us on this exploration. We really hope these concepts are clearer now, maybe a bit more memorable and useful for whatever you're learning. Until next time on the deep dive.